Jacob Zuma and the MK party launched an urgent legal bid challenging some of President Cyril Ramaphosa's recent decisions, notably placing Police Minister Senzo Mchunu on special leave, appointing Firas Kakelia as acting police minister, and the establishment of the Commission of Inquiry. But in the latest twist, the Constitutional Court, ConCourt, has dismissed their urgent application, saying it was procedurally wrong. Zuma and MK should have approached the High Court first. The Apex Court emphasized that their case did not present sufficient exceptional circumstances to justify skipping the usual route, and declined direct access. The legal journey began when Zuma and the MK party filed the matter at ConCourt, seeking to have Ramaphosa's decisions declared invalid or unconstitutional. Their application argued that the decisions taken by the president violated constitutional norms, and they sought relief on an urgent basis. They claimed urgency, contending that waiting for normal court processes would allow irreversible harm. But ConCourt found that the applicants had not justified why they bypassed ordinary court processes. Justice Ramaka Stephen Mathopo, delivering the judgment, said that Zuma and MK had failed to explain adequately why they did not first bring the matter before the High Court. The Constitution allows for direct access to ConCourt only in limited circumstances. In this case, ConCourt held that issues raised did not fall within its exclusive jurisdiction, nor did the applicants show that the importance or gravity of the matter justifies a departure from the usual route. The court said, essentially, that skipping the High Court was not justified by the arguments presented. Mathopo also made clear that the fact that an issue might later rise to ConCourt review does not mean ConCourt should be the court of first instance. He warned that reliance on importance alone is not enough. The purpose of the hierarchical court system is to allow evidence to be tested, factual records to be built, then points of law to be developed in stages. These intermediate steps matter in upholding procedural fairness. Because the matter was not appropriate for direct access, the ConCourt refused to entertain the urgency or merits of the arguments, and dismissed the application. The MK party and Zuma's challenge had centered on the idea that President Ramaphosa overstepped his powers by placing Mchunu on special leave and appointing Kakelia in the interim, while a commission of inquiry was being established to investigate claims of criminal syndicates and interference in policing. They argued that the move undermined principles of administrative fairness and separation of powers. But ConCourt held that the proper vehicle was the High Court, where such questions of administrative law and constitutional review should first be ventilated. Previously, in July 2025, ConCourt had already declined to grant direct access in this same matter. That earlier ruling indicated that the court viewed the case as one that should be dealt with via the normal court ladder, High Court, Supreme Court of Appeal, and then, if necessary, the Constitutional Court. In fact, in its earlier decision, ConCourt said the matter did not fall into its exclusive jurisdiction and that Zuma and the MK party had not made a compelling case for skipping steps. Having already made that finding, ConCourt's dismissal now reinforces that procedural doctrine. The recent ruling confirms that Zuma and MK's attempt to shortcut the legal process was improper, invalid in terms of jurisdiction, and unsustainable. Zuma and the MK party had dug into claims that the commission and the special leave were part of a scheme to shield political actors and manipulate the outcome of investigations. They argued that a commission of inquiry was premature, that the interim appointments were suspect, and that the president's actions were tainted by improper motive. Yet ConCourt's dismissal means those substantive questions will have to wait. They will need to be reintroduced at the correct forum if they are to be argued at all. Already, Zuma has not conceded defeat. Reports indicate that he and MK have lodged a fresh urgent application to the High Court in Pretoria, hitting the usual procedural route. In that application, they seek what they initially sought at ConCourt, that Mchunu's special leave be declared invalid, that Kakelia's appointment be overturned, and that the Commission of Inquiry be nullified. They are essentially attempting to re-argue the same issues, now in the proper court. Whether the High Court accepts the urgency, or whether it will allow the matter to proceed on an expedited basis, remains to be seen. For Zuma, this legal strategy is risky. If the High Court refuses urgency or declines to entertain the case on the merits, then the MK party may lose momentum or credibility. But by starting in the proper court, they at least remove the procedural bar that ConCourt cited as fatal in their first bid. The question will be whether the High Court finds sufficient grounds in their arguments and evidence to justify setting aside or reviewing those presidential decisions. The judgment also poses broader institutional implications. ConCourt's insistence on procedurally correct pathways underlines the role of the judiciary not just in adjudicating substance, but in preserving the architecture of legal process. By refusing to accept an application that jumped over critical steps, the court reaffirms that access to justice must follow rules designed to protect fairness and to allow robust fact-finding. In effect, the court is reminding all parties, no matter how powerful, that constitutional and administrative challenges must often be built from the ground up, not parachuted into the highest court on short notice. From a political perspective, the outcome is equally consequential. Zuma's MK party has positioned itself as a force of resistance to perceived overreach by the executive. The legal front is part of its strategy to challenge the balance of power and to cast Ramaphosa's moves as undemocratic. But the procedural setback could weaken that posture. Opponents will seize on the dismissal to argue that Zuma and MK are seeking shortcuts rather than engaging the full judicial process. The optics of being rebuffed by ConCourt may cost political capital, especially among constituencies that value order, institutional trust, and rule of law. At the same time, the move to approach the High Court may mitigate that damage. If the High Court entertains the case, hears evidence, and makes substantive rulings, that legal process could restore outlook for Zuma and MK. But they now must navigate evidentiary challenges, legal resistance from the state, and possible procedural objections from Ramaphosa's defenders. They must show that they have legal standing, sound arguments, facts to back claims, and that urgency is justified, without relying on political theater. One lingering question is whether any of the decisions they challenge will already have become irreversible by the time a court considers them. For example, Mchunu's special leave may end, Kakelia's tenure may continue, and the commission may proceed with work. Courts often tread carefully where undoing executive decisions may cause disruption or uncertainty. Zuma and MK will need to make credible arguments that hardship or prejudice justifies intervention even amid institutional changes. Another point of interest will be the interplay between the Judicial Inquiry, Madlanga Commission, and this legal battle. Many of the claims Zuma and MK are contesting relate to decisions tied to that commission. The court process may intersect or influence the commission's work or its mandate. Observers will watch whether the judicial processes limit or enable investigative authority, how overlap is managed, and whether findings from the commission influence or are influenced by parallel court proceedings. For the ANC and Ramaphosa, this dismissal is a relief. It removes one immediate threat of an adverse court ruling against presidential decisions, and signals that challenges must proceed through established legal channels rather than shortcuts. Their legal team had already argued that Zuma and MK's original approach was procedurally flawed, claiming the matter belonged in the High Court. Now ConCourt's ruling gives judicial backing to that line. Moving forward, Ramaphosa's side will likely argue that any future legal challenge must contend with the fact that ConCourt has already rejected the procedural approach Zuma tried. Yet the dismissal also signals that ConCourt did not resolve the merits. By refusing to hear the case, the court did not opine on whether placing Mchunu on leave or appointing Kakelia was lawful or not. Those substantive constitutional questions remain unresolved. If Zuma and MK proceed in the High Court, those issues will be litigated on their merits for the first time. ConCourt's ruling is procedural, not in substance, leaving the door open for future legal battles. The case also highlights a broader tension between political urgency and legal caution. Zuma and MK framed their case as urgent, arguing that delay would allow harm and shift power in ways that could not be reversed. But courts are wary of permitting urgency to override procedural safeguards. In emphasizing that importance alone is not enough, ConCourt reaffirmed that even major or politically weighty matters must still pass procedural filters. Without that check, courts could be flooded with parasitic, last-minute challenges that burden institutions and undermine orderly governance. In the national narrative, the outcome will likely be seen as a setback for Zuma and MK's legal strategy. Political commentators may interpret it as evidence that bypass attempts are failing. Some supporters may argue that the procedural ruling masks substantive injustice. But legal observers will note that the decision underscores the separation of powers. Courts must refuse to act where jurisdiction is not properly engaged, not because they endorse the executive decisions. Where the case goes next will matter. If the High Court accepts the application, it will need to decide whether to hear urgent relief, whether to suspend the contested decisions, and whether to rule on the constitutionality of Ramaphosa's actions. The degree to which the state defends those decisions forcefully, the evidence that Zuma and MK bring, and the balance between interim and permanent relief all will shape outcomes. If the High Court denies relief, Zuma and MK may still appeal up to the Supreme Court of Appeal or Constitutional Court, but only after building a full record. This episode may leave a lasting lesson in South Africa's constitutional order that power must be challenged, but challenges must follow constitutional design. Shortcuts, no matter how well publicized, cannot substitute for procedural legitimacy. In the end, the legitimacy of outcomes depends on how they are achieved, not just on what is argued, but how the courts are approached. Whatever happens, the ConCourt's dismissal marks a critical moment. Zuma and MK's attempt at direct access was curtailed. They must now re-engage in the High Court as required by the legal order. Their persistence may continue, but under stricter rules. Whether they rise or fall in future courts, they now must contend with the fact that ConCourt already imposed a boundary they tried to cross, and failed.